Hello, thank you. It's good to be here. I happened to walk into the room and they said, "Hey, you're the MC now." But how long's Hacker Court? There's been a ninth year, and I was there for I think the very first one, and it's I've been involved in it off and on over the years. It's a fun little thing. This is exactly how regular court works. Okay. There is a completely 100% accurate. So, everyone else sits at a big table. The judge stands back in the back and, waits and stuff. No, it's mainly all the boring parts of court are going to be skipped, and the good parts that are going to be pertinent to what's going on is what's mainly going to be presented to everyone. So let's go through and introduce everyone. We'll talk about who they are. Our judge is Richard Salgado. He's the one in the judge robe, which you got from Judges R Us, I guess. And but he's a professor at Stanford Law. And let's see, where's Carol? Carol is down front. She is our court clerk, our bailiff, and no longer the MC. And she's the one that kind of puts this together every year. This is kind of her baby, so there she is. Prosecutor, Mr. Paul Ohm from the University of Colorado. On defense, we have Kurt, I always get your name wrong. Opsahl. Kurt Opsahl, who's with the EFF. And we also have Kevin Bankston, who's also with the EFF, who's also here. Yeah, very good. We have our case agent, Richard Stroker, who is being portrayed by John Klein, who is right here, who for some reason got out of working at a financial company to come here and play dress up. And let's see here. Carol is also playing the role of Maria Batali, the Director of Security at MyTwitFace, the company in question. We have Biz Zuckerson, the CEO of MyTwitFace, being portrayed by Mr. Richard Thiem here. Joel Hobbs, the defense expert. Name, I'm not sure what that's supposed to be. Oh, that's left over? They filled in his name, actually. See, it's just like regular court. They get things wrong on the slides all the time. Anyway, David Kane Perry, who's right down here, recently engaged. If you saw his talk earlier today, he actually proposed from a slide during his talk at Blackhat. So he is the ultimate nerd. He wins. And then our defendant and my cohort in crime, Weasel down there. He is the lead coder, and he has Vaporaspora. That's the company, I assume, that the project that the evil lead coder. I shouldn't say evil. That's actually far from evil. His attorneys say he's far from evil. Anyway, but he's a fellow guy from NMRC. Anyway, these are the cast of characters here. And I think, are we ready to...
Just a quick schedule.
Oh, yeah, here's the schedule. I'm not going to read through it. You guys can figure it out. This does span over a break, and you all are, I guess, welcome at that point to take a bio break, but come right back and bring your friends, et cetera, et cetera. Text them, tell them to get in here, et cetera. So with that, I think we're ready to get going. So do I have a...
Bang the podium.
Okay, hold on here a sec. Hear ye, all rise. Hacker Court is now in session. The Honorable Richard Salgado presiding.
You may be seated. You may be seated. Thank you, ladies and gentlemen, and counsel. I see that the jury has been impaneled and has been sworn, all 12 of you. Counsel, would you please enter your appearances? I'll start with the government.
Good afternoon, Your Honor. Paul Ohm, representing the United States of America.
Thank you. Defense?
Kurt Opsahl, representing the defendant.
Kevin Bankston for the defendant. For the defendant.
Thank you, counsel. Before we begin formally, I want to thank the members of the jury for participating today in one of the most important civil duties that you can fulfill, and for not being creative enough to think of a way to avoid the service today. And I'd like, on behalf of the government, to thank you and express my gratitude for your performing the obligations that you have as citizens in this country to ensure that the judicial system is fair and impartial. Let me describe briefly before we begin how the trial is going to proceed. It's a criminal case. That means that charges are being brought by the United States, the prosecution represented here by Mr. Paul Ohm, against the defendant, who's being represented by counsel who's introduced themselves already. The indictment in this case is a document that sets out the charges against the defendant, and in this case there are 3 charges that have been alleged by the government. Before I go through those, let me say that all this document is a finding by the grand jury that there's probable cause to believe that the defendant has committed the counts that are charged in the indictment, but it is not proof that the defendant is guilty. It is your job to determine whether there has been enough evidence to establish that the defendant is guilty beyond a reasonable doubt or not. In this case, the defendant is charged with 3 counts. One is eavesdropping illegally on oral communications. The second count is that the defendant illegally intercepted electronic communications. And the third count is that the defendant accessed a computer and obtained information without authorization to do so. Now, this is just a summary of the charges. You'll be getting much more detailed description on the elements that the government has to prove in order to establish a case of guilt against the defendant. For any count, the defendant must be found not guilty if there is not a unanimous verdict in favor of the government that the defendant is guilty beyond a reasonable doubt. The first step in this process is going to be opening statements by the government, and if the defense wishes, the defense can then follow with their opening statements. Then we will move on to the presentation of evidence. That's the evidence that you'll be considering in determining whether the defendant is guilty or not the opening statements. Those are just statements of counsel. We will go through the witnesses of the prosecution first, and the defense will have the opportunity to cross-examine. Then we will turn to the defense, and if the defense has witnesses that they would like to call, we will be hearing from the defense witnesses. After that, I will be instructing you on the elements of the crimes that are being charged. You will hear closing arguments to the extent counsel wishes to present those closing arguments, and then you will deliberate, and you will have to determine whether the government has proved its case against the defendants. So with that in mind, let's get started with opening statements. Mr. Ohm, do you have an opening statement?
Yes, Your Honor, I do. I'll move down here. My athleticism for the day. Look at that. Ladies and gentlemen of the jury, thank you very much once again for your service. I wanted to echo what the judge said. The government, the United States of America, thanks you for taking the time out of your busy schedules to help us talk about what happened here and what brings us to this room. My name is Paul Ohm, as you've heard, and I represent the United States of America. This is a case about a brazen attack on privacy. If you look at the defense table, you'll see a gentleman, perhaps not dressed as nicely as he should be for his day in court. That man, Weasel, is the reason we're all here today. He is a disgruntled ex-employee of MyTwitFace. Now, I know that many of you probably are aware of MyTwitFace. Please put out of your mind what you know about the company, and I'm sure there are even users of the company here. But allow us, through the witnesses, to present the evidence in this case, because this is a case about this man Weasel and what he did to MyTwitFace. He was a man who was once trusted by the company. He was an employee. He was allowed into the inner sanctum of the company. He left under less than savory circumstances, and then he abused that trust. He took what had been given to him by the people who work at this company and essentially threw it on the ground and stamped it underfoot and abused the privacy and trust. But it's worse than that. He chose to victimize not only the company, but also a particular individual, the CEO of the company, Biz Zuckerson. And you'll hear from Biz soon. And you'll be shocked, I believe, to learn what this man did to Biz Zuckerson. He infiltrated this man's laptop, this poor innocent victim. He sat and took control of all of the functionality of that laptop, turning it into a powerful tool of privacy invasion and surveillance. He turned on the video camera to watch what Mr. Zuckerson was doing in the privacy of his home with his friends. He periodically took screenshots to see the private communications that Mr. Zuckerson would have with his colleagues and compatriots. You should begin to see a picture of this man sitting in Mr. Zuckerson's bedroom and his bathroom and his kitchen and his living room. Wherever that laptop went, this man would follow. And thankfully, fortunately, we have laws. We have laws that both punish people for doing things like this man did, and laws that deter others who would follow in the example led by people like this man. And you, the jury, are here today to see if these laws will do justice. You will also hear some testimony today about motive. What would drive an individual to do something like I described? But I want you to be careful. This isn't a morality play. This isn't about weighing whether or not anger or greed or jealousy or whatever motive it is justifies something like this. This is about a man so driven by all of the motives that drove him here today, who continues today to benefit directly and significantly from the acts he did. And so there's going to be a lot of fight about why he didn't do it. But at the end of the day, this isn't about was he right or was he wrong. It was, did he do what the law forbade him from doing? And the last thing I want to say, ladies and gentlemen of the jury, is these internet-based cases can be quite complicated. You will hear a lot of technical jargon and lingo. It's my job as the attorney to guide the witnesses to explaining what happened today. But understand one thing about this case. This isn't a complicated case that turns on an advanced knowledge of computer networks that requires a PhD to comprehend. No, this is a case where the main proof that the act was done was spoken by the defendant himself. This is a case where the defendant confessed to everything that I've alleged that he has done. And you will hear, through the case agent in this case, the words of the defendant upon arrest confessing to the crime. And so it is for you to sort out some of the other details. The judge will inform you of your duties and tell you how to interpret the law, but that will come at the end of the argument. We think, the government thinks, that after our presentation at the evidence, after the defendant has what he has to say, if he wants to say anything at all, will lead you to the only verdict that is supported by the facts, and that's a verdict of guilty. Thank you.
Thank you, Mr. Owen. Mr. Opsahl?
Thank you. May it please the court, Your Honor, ladies and gentlemen of the jury, my name is Kurt Opsahl, counsel for the defendant. Together with my colleague Kevin Bankson over here at this table, I'm proud and privileged to represent Mr. Weasel. I'm proud to represent Mr. Weasel because he is a hero. Faced with a near constant erosion of privacy on social networks like my Twitface, he left that company and he created Vaporospora, a nonprofit, peer-to-peer, open-source, privacy-protective, full-featured social network at no cost to the user. Weasel only wished to compete with my Twitface in the marketplace of ideas. But the marketplace of ideas is nothing if the public is kept in the dark about the truth about my Twitface. And that is the motive that you will see. The motive that Mr. Weasel had was to inform the public about the truth, and so they could see what Mr. Zuckerson has been up to, what he was planning with my Twitface, and understand why they should question whether they should be on my twit face. But Mr. Zuckerman couldn't handle that truth. He saw Mr. Weasel as a threat. And today you will hear the story of overzealous goon squad sent to kick down door after door in an effort to track down Mr. Weasel because they didn't like a news story that exposed the truth. Under pressure from the company, the government trumped up whatever charges it could, but these charges, you will find, are no good. First, they try and shoehorn a silent video taken of a plot underway at Mr. Zuckerman's house. And they try and shoehorn that into a statute that was designed for the interception of phone calls. You will listen closely as the government witnesses testify, and you will hear nothing about any sound that was captured. And if the sound did not transmit, you must acquit. Nor is the government's case for the captured screenshots, the interception of communications charge. This is not any better, because these are federal laws. We are being prosecuted here by the United States of America, and the United States of America has to limit itself to interstate activities. They must involve a system that affects interstate or foreign commerce. What matters is the point of capture. It's not relevant whether or not the instant messages that were found, exposed, and brought to the world through the newspaper article were eventually, or at some point, transmitted over the internet. At the point of capture, when the screen grab took place, they were just in between the video buffer and the hard drive. It was inside the computer. The evidence will show that there was no transfer from one state to another, no international transfer, nothing going on like that at the point of capture of that information. Finally, they took at what at best might be a misdemeanor charge of computer intrusion and trumped up a felony charge by the ludicrous theory that Mr. Weasel had a financial motive, that he was doing this for his own personal gain. But Mr. Weasel, he takes no salary. He has no possibility in selling any shares of this nonprofit open source project. He is a volunteer who spends his time, day in and day out, freely giving his expertise in coding to a project. Sure, Vapor Aspera may have gotten some more users as a result of this, but that was because people realized the truth about my twit face and they made their choice to go to a more privacy protective service. This is not a financial gain to Mr. Weasel, it is a privacy gain to the users. And without a financial motive, without that private financial gain, you must acquit. Thank you.
Thank you, Mr. Oxall. Mr. Ohm, you may call your first witness.
The government calls Biz Zuckerson to the stand, please.
Mr. Zuckerson, will you please raise your left hand? Do you promise to tell the truth, the whole truth, under the pains and penalties of perjury?
I do.
Thank you. Mr. Ohm?
Thank you, Your Honor. Mr. Zuckerson, good to see you. How are you doing this afternoon?
I'm fine, thank you.
Could you please state your name and title for the jury?
Yes, I'm Biz Zuckerman. I'm the founder and the president and the CEO of the world's largest and most successful social network, My Twit Face.
Yes, and I'm well aware of My Twit Face. Can you please tell the jury a little bit more about My Twit Face?
It's, well, other than fire, it's probably the next best thing that humanity has received as a gift. It's a safe, it's respectful, it's an online environment that helps you connect with people, with heart to heart and brain to brain, sharing with friends and families and colleagues and lovers and ex-lovers and haters and friendly rivals and rivals' friends and anyone you want, really. Practically every American and many more have a My Twit Face profile now. We have almost 500 million members worldwide.
And so just so the jury understands, this is a lot like Facebook, right?
Yeah, like Mars is like Uranus. No, absolutely not. Or perhaps if it is at all, it's very superficially so. I'm proud to say my TwitFace takes the best features of our competitors, of course, and improves upon them with advanced privacy features. We have the best privacy policy in the business, so you know that anything you share on my TwitFace is only shared when you choose and to whom you choose. I don't want to brag. I'm not grandiose or anything, you know, but we are the preeminent social utility of the 21st century. And part of the reason is we understand and we respect you, the user, and your need for privacy in a way that something like Facebook never will.
So let's talk about what brought you to found this. Why and how did you create the story? Just tell us the story of my TwitFace.
Because there was a vacuum in the human mind space, and I perceived that I was one of the only ones on the planet who could fill it. I was personally offended. You know, this really isn't difficult for me. I was personally offended and very disappointed by how shoddy the other services were. I knew we could do better. No one had the intellect, the unmatched understanding of the needs of the online consumer that I bring to this space.
And how's the company been doing?
Oh, incredibly well. It had been doing incredibly well. Thanks to my work, I work 24/7 to make it one of the greatest utilities humans have ever had opportunity to use. And thanks to my endless appearances in the media, I've been on every digital and print media form imaginable. They chase me through the hallways wanting interviews to sing the praises of this unique and unmatchable service and explain our superiority. Our growth is phenomenal. Before this incident with Mr. Weasel, we had reached our 500 millionth user.
So let's turn to this incident to which you refer, and I want to take you back to January 25th, earlier this year. How did that day start out for you?
Not very well. I woke up and I still get a morning paper. It's a print thing that they bring to your door. And I saw this awful, slanderous story about me and my business, and it used information, distorted it, that was clearly taken from my own computer without my knowledge.
So, Mr. Zuckerson, if you will, please look at the fake pile of exhibits in front of you.
Yes.
And turn to Exhibit 1.
Okay.
Do you recognize what's in front of you?
I certainly do.
And what is that? Can you identify that for the jury?
It's an article about my TwitFace and myself.
And so this is the article that we were talking about a second ago that you read on January 25th.
That is correct. Thank you, sir.
And if it's not, oh, Your Honor, the government would like to admit the newspaper article as Exhibit 1 and publish it to the jury.
Any objection, defense?
No objection.
It's admitted.
So, Mr. Zuckerson, if it's not too painful to have you relive this, could you please read some of the story for the jury?
My TwitFace, the world's most popular social networking site, has been revealed to have pursued a shocking surveillance agenda. This is disgusting. Against its users, despite CEO Biz Zuckerson's assurance that user privacy is of paramount importance to the company. In an exclusive anonymous disclosure, FUD News has learned that my TwitFace has mined information from users while encouraging them to reveal personal details under the false assurance that the information would remain private, much like a cattle farmer cultivates his herd. Zuckerson's nefarious plot was revealed in an exclusive video obtained from one of the sordid parties held at his palatial estate. They're not sordid. These parties, regularly attended by influential power brokers like Oprah, Bill Clinton, George Clooney, Lady Gaga, and Justin Bieber, were actually meetings to advance an agenda designed to control world events through social and entertainment media. The evil plot was revealed in a video that was exclusively obtained by FUD News and shows a slide presentation with details of the plan. The details and breadth of this plot are shocking. This is just, I can't even read this crap. Do I have to keep reading?
No, I understand. I think the jury has a feel for the story, and it will be in their exhibit book back in the jury room. But you did mention in an earlier answer that from reading the entire story, you believe that some things were taken from your computer. Can you tell me what you think was taken?
Yeah, there were three things. First, an IM chat with an old friend of mine in Alaska, a presentation slide deck that I showed to friends at a party on my laptop, and the most shocking of all, videos of my friends at the party watching the presentation.
And could you please describe for the jury how you reacted to finding out about this story? How did you take the news?
I was incredibly upset. these journalistic vultures were taking my personal jokes with my friends and trying to call into question my integrity and the integrity of my Twitface, my company.
And I'm sorry, you are a very strong individual for getting through this. Thank you again for bearing with us. Let's now talk about what you did in reaction to the story. Did you react to the story? Did you try and take any steps because of it?
Absolutely. I'm a can-do sort of guy, and I immediately called head of security, Ms. Battelle, and demanded that she identify the leak by whatever means necessary. I didn't care if it took lie detectors or strip searches or reverse strip searches or video cameras in every corner of the office. Chinese water toucher, I didn't care. We had to find the leak and plug the leak. I told her if she had trouble coming up with the ideas, what to do, just call my buddy, Steve Jobs. He knows how to handle this kind of thing.
And did you call anybody else?
Yes, I called the CBI, the California Bureau of Investigation, and they sent Richard Stroker, an agent. But he came back within a few weeks, and he said he'd run into a brick wall. Well, that damn well wasn't good enough for me. I called my friends at Overreact instead. I knew they'd hop to it.
So Overreact, could you please explain what Overreact is?
Yes, I'm very proud of them. Overreact is Silicon Valley's preeminent high-tech law enforcement task force. It's a joint task force of U.S. law enforcement working in cooperation with technology companies like ours to crack down on high-tech crimes like these. You might have heard of REACT, the Rapid Enforcement Allied Computer Team. They got a lot of publicity in a case about Apple's new iPhone and a raid on a journalist's home. I thought they did a hell of a good job. Overreact is like React, but more. It's better, it's faster, it's smarter, and it's more ballsy. Being on their advisory board, I knew they'd get the job done. So when the FBI couldn't move fast enough, I knew it was time to overreact. I mean, to call overreact.
Please tell the jury about that call.
All right. On February 24th, I made the call. The next day, Richard Stroker contacted me and said he'd come right over to the office and talk to Ms. Battelle, our head of security. Things moved along pretty quickly at that point.
Thank you. I'm going to talk to Mr. Stroker later about the investigation itself. I want to just jump ahead past the investigation and just tell me about what the effect of the newspaper article has been in a long-term sense. What has it done to your company?
It has been awful. These are lies about how I disrespect my users' privacy, and as if I have some ill-defined plot to use their information to take over the world. They've been repeated in every news organ around the world. The reputation of my Twitface has been damaged irretrievably. We have already seen several million my Twitfacers leave my service. I assume for other social networks like this ridiculous Vaporaspora project.
Objection, speculative, and pardon the very loud microphone.
Well, it needs reinforcement and amplification. We've seen several million users leave our service, and many fewer new people are signing up. It makes me worry that my plan for dominating the world, my plan for dominating the social networking space will never come to fruition.
Thank you, Mr. Zuckerson. No further questions. You're still up there. You got a question. No further questions
Defense, do
from
you
me.
have questions?
Yes, Your Honor. I suppose that the esteemed Mr. Zuckerson is, if we have him for the day, we might as well ask him a few questions. Hello, sir. Thank you for being here.
You represent Weasel?
Yes, sir, I do.
Yeah, okay.
I just wanted to clarify your position on a few things. So you would say that my Twitface is a leader when it comes to providing private ways to be social online.
Absolutely. We've pioneered all sorts of developments that now others are imitating and stealing.
So you'd say your privacy controls are state of the art?
I would say we have done everything we can to ensure the privacy of every communication sharing on our network.
Oh, well, that's certainly nice to hear. So you wouldn't say have a secret plan to exploit your users' information to take over the...
I'm busy creating something of value for every human being on this planet. How the hell could I be concerned with world domination?
So you are not, I don't want to say, conspiring with Bill Clinton and Oprah and Kim Jong-il and Justin Bieber to exploit your users' information to take control of the world?
Justin Bieber, I don't know how he got into that party. That's number one. I called Rent-A-Boy, and they sent us... I thought he was just going to carry hors d'oeuvres, but then there's that video of me carrying the hors d'oeuvres. But at any rate, no,
Your answer is no.
Of course not.
Okay.
Of course not. Clinton, Oprah, whatever, Kim, do
So
that sort of thing, but I
users-
don't know. No.
Your users' privacy is of paramount importance to you personally, isn't it?
Yes, because it's the only way we can ensure a discrete experience that has integrity and leaves the user as whole and intact when they finish their experience with our network as when they came to us. We're concerned about the wholeness of the human being. We don't just try to exploit and use people and make money and, as you say, dominate the world.
Glad to hear that. Thank you very much. Mr.
You're very
Zuckerson.
welcome.
Mr. Owen, would you like to rehabilitate your witness?
I don't think that's possible, Your Honor. No further questions.
You may be excused.
It's been a pleasure.
You may call your next witness.
Yes, the government calls Maria Batali.
Ms. Vitale, would you raise your left hand, please? Do you promise to stick to the script or under threat of not being invited back next year?
You betcha.
Good afternoon, Ms. Batali. How are you?
Fine, thank you. How
Could
are
you please state your name and title to the jury?
My name is Maria Batali. I am the head of security at My Twitface.
And could you please explain your job responsibilities?
I'm the worldwide head of security for My Twitface. I secure the networks, I secure the computers, I secure the physical plant, I do background checks on prospective hires, and run our team of corporate espionage agents.
And can you tell the jury a little bit about your particular approach to security? Do you have a philosophy about security?
2 words, total control. Nothing comes into my building, not by the doors, the windows, the wires, or through air ducts, without my having approved it first. I consider George Orwell's 1984 to be an excellent corporate handbook.
And how about surveillance, then? Does your approach involve any surveillance?
Oh, you betcha. I started a program called Total Information Awareness. This was back in 1999, before the government stole my idea. My motto is, show me a flat surface, and I'll show you how to mount a camera on it. I use video cameras, microphones, RFID tags, heat-sensing cameras, Geiger counters, you name it.
And how about laptop security, the topic that brings us today? Did you ever worry about the security of the laptops of your employees?
Yes, those laptops kept me up at night. I hated the idea that we let them things out of our facilities, full of our secrets, available to spouses, kids, squirrels, and other people's networks.
So why didn't you just ban laptops?
Well, I did try. The whiny users complained. They had all sorts of sob stories about working from home, going to conferences, taking care of sick kids, just whiners.
And what did you do then to secure these laptops?
Well, I did a lot, but I really learned a lot from the folks at the Lower Marion High School district outside Philly. Those guys are visionaries.
So can you please tell the jury what you're talking about?
I'm talking about ambiguous manage.
And what's ambiguous manage?
Ambiguous manage is a beautiful piece of software technology. It follows the total information awareness mantra. It co-ops the laptop video camera, turning it into a remote video surveillance device. It logs keystrokes. It captures screenshots. It tracks location by tracking Wi-Fi hotspots. It turns on Bluetooth to try to enumerate cell phones nearby. It takes a simple little laptop and turns it into the perfect tool for corporate surveillance. It's just a wonderful tool.
I can tell you're a fan. I'll let you have a moment just to bask in that. So let's now turn to the events that bring us here today. Do you remember the events of January 25th?
I do. It's the darkest day of my life.
And why do you say that?
It's the day I learned my security system wasn't perfect.
So are you referring to the newspaper article?
Oh, that damn newspaper article.
So what happened? Tell the jury about January 25th.
Biz called me into his office. He was livid. He was grasping a copy of the newspaper article.
And what did he say to you?
3 words. Find the leak.
And how did you interpret that? What did you interpret that to mean?
He wanted me to find out how the journalist knew what she knew.
Okay, so then you have this order from Biz. What did you do next?
Well, we have a protocol for this sort of thing. It's a rendition incident response protocol.
Okay, and what's this protocol require you to do?
Well, first we go into total lockdown. We lock down all the offices. People can't go in or out. We electrify the fences. We take any compromised systems offline, check file hash signatures, IDS logs, other logs, run packet sniffers, and then we release the hounds.
So I'm sorry, I don't know that. Hounds, this is a kind of packet sniffer you're referring to?
No, hounds. Dogs. We strip search all employees, administer lie detectors, truth serum, waterboarding. You know, typical CISSP cube stuff.
Okay. And did any of this turn up any leads?
Most of it didn't, but it was a lot of fun. Most of it was mostly for show, you know, just scare the employees, keep them in line. We knew that the key was Zuckerson's laptop because of the screenshot and video.
And so what did you do with Zuckerson's laptop?
I ran a sniffer and discovered, to my horror and dismay, that the copy of ambiguous manage running on the laptop wasn't communicating with my server. It was communicating with a computer owned by an employee named Brutish.
And so did your attention turn to Brutish? Did you suspect Brutish for this?
We did at first. We interrogated him. Let's just say we're positive he wasn't lying when he said he didn't do it.
Okay. And so what did you do next?
We looked through our IDS logs for suspicious communications with Brutish's computer.
And did you learn anything from those logs?
There were a lot of recent packets from an IP address 10.1.1.1.
And so what did you do with this IP address?
Unfortunately, not very much. It tracked back to a Verizon broadband customer in Philadelphia, and I called Verizon's security team, and though they said they'd investigate, they wouldn't tell me anything about the computer.
So what did you do next?
I went to Biz and told them that we had to go to law enforcement.
And then what happened next?
Biz called the cops.
Great. Thank you. You're a witness.
Thank you. Just a few questions, Ms. Batali. Truth serum,
Yeah,
okay. Strip searches,
standard procedure.
video surveillance.
Yeah.
Is it fair to say that you place the security and business interests of my TwitBase over the personal privacy of its employees?
We respect the privacy of our employees, but they wouldn't be employees without my TwitFace.
I'm not sure I understand.
What was the question?
Is it fair to say that you value the business and security interests of my TwitBase over the personal privacy of my TwitBase's employees?
Well, they do understand that they are subject to monitoring.
Is that a yes?
Yes.
What about my TwitFace's users? Did you take any steps involving my TwitFace users' information in trying to track down the source of this leak?
Well, we do have our list of users who are known to be the bad users.
I'm sorry, the bad users.
Well, these are the ones who have published certain subversive content, things that we have profiled that could be some problems for our network. We need to protect our network and our other users.
Subversive, would that include people who have simply criticized my TwitFace?
Well, criticizing my TwitBase is subversive.
So this is essentially an enemies list that you've
Objection,
made.
Your Honor. I don't see how this is relevant to the case.
Your Honor, it's relevant in regard to my client's motive to expose the lack of respect of privacy of my TwitFace.
All right, I'll allow it to continue,
Thank you.
subject to you tying it up with a later witness.
I'll wrap it up very quickly, Your Honor. Indeed, I don't think I have any further questions. I think that does it. Thank you.
Thank you. Mr. Ohm, do you have any further direct?
No further questions, Your Honor.
You're excused. You can call your next witness.
The government calls Richard Stroker. People are just getting it.
You raise your left hand. I understand you're a law enforcement official?
Yes, sir.
All right, well, there's no need for an oath.
Thank you, sir.
So should we call you Richard then?
Oh, just call me Dick.
Okay. Dick, could you please state your name and occupation?
Yes, sir. Richard Dick Stroker, Special Agent with the California Bureau of Investigation, currently assigned to the Overreact Task Force.
And don't you think the last few jokes have been a little too obvious? No. All right. So first question.
Actually, to answer that, sometimes we've had a slow audience.
Okay. What's your area of specialty?
Yes, I specialize in computer crimes investigations. I'm also a certified computer and network forensics analyst. I've got all kinds of certifications, too many to enumerate right now.
Your Honor, I'd remind the court that we previously qualified Agent Stroker as an expert in the areas of network and computer forensics.
That's accurate. We'll let the record reflect that the witness has been qualified as an expert.
Okay, so how did you first become involved in the investigation that brings us here today?
So our office received a call on the 25th of January from Mr. Biz Zuckerson, very upset about something, complaining about a breach of security on his personal computer.
And what did you do first?
Well, I visited the company and I went to Mr. Zuckerson's house, Thanks to the work already done by Ms. Battaglia, I'd like to say I think very highly of the work that she's done. I think 1984 was also a very good handbook on security. So based on the work done by Ms. Battaglia, I tracked the attack quickly to a specific IP address, 10.1.1.1.
And what did you do next?
Well, using the public database lookups, I determined that the IP address was being used by a FiOS customer in Philadelphia.
So what steps did you take to investigate the Philadelphia computer? Sorry.
Because Ms. Battaglia obviously did a much better job than I did on finding this. Well, I contacted my counterparts in Philly, and together we drafted a search warrant for the computer, which we executed a few days later.
And did you discover anything when you examined that computer?
Unfortunately not very much. There was no evidence whatsoever that related back to the defendant. There was, however, an installation of Tor. The machine had been configured as a Tor exit node.
And what did you conclude from this?
Well, whoever compromised the laptop's security probably used Tor to hide his tracks.
And so could you look at log files or use Tor to find out any evidence of who that person was?
No, sir, I wish we could, but Tor nodes don't tend to create any traces of evidence, and there was no log file.
Okay, so what did you do next?
Well, at first I figured we were at a dead end, so I didn't think there was anything left for us to do. The only lead I had left was a potential journalist, and I didn't want to go there.
So what do you mean you didn't want to go there?
Well, we're reminded pretty frequently to treat journalists very carefully.
Sorry, I'm still not following. Can you explain to the jury what you mean by
So
that?
during our training at the Overreact unit, we're taught that because of the First Amendment and the Privacy Protection Act, we're not supposed to get warrants for journalists' computers if we don't suspect the journalist of having committed the crime himself.
And so did you call the journalist?
I did.
And what did the journalist tell you?
Said that his sources were confidential. He wouldn't voluntarily help out.
Okay, so what did you do after this?
Not much I could do. I called Mr. Zuckerson and Ms. Battaglia, and I gave them the bad news. They were obviously disappointed. Actually, they were very distressed and screamed a lot of bad words at me, which I can't repeat for the court. But I thought they'd understood.
Okay, so what happened next then?
Well, the next day my boss came into my office. He explained that the situation had changed.
What did he mean by change?
Well, he let me know that the case had been elevated into an Overreact Tier 1 case, which meant that we had to put it to the top of our list. It also meant we'd be willing to do a bit more aggressive about things.
And what impact did that reclassification have on this case? What did it mean?
It meant we went to go raid the journalist's house.
And so that's what you did?
Yes, we went to a judge and got a warrant to search the journalist's house.
Okay, so what happened next?
Well, we executed the warrant.
So please turn in the exhibit folder in front of you to tab 2. Do you recognize this document?
Yes, I do. It's the search warrant inventory.
Okay, and Your Honor, the government moves exhibit 2 into evidence.
Any objection? It's admitted.
So this is the inventory. What do you mean by that?
Well, this is everything that we seized from Mr. Ross, the journalist's location.
And because the print is kind of small, just to give the jury a feel for what this is, could you read maybe the first 5 or 10 entries on what you took from the journalist's house?
Yes, we seized 1 box of business cards for subject clients, 1 Apple notebook white with power cord, 1 Seagate external 250 gigabyte hard drive, 1 microwave oven.
Microwave oven?
Well, it was one of those, looked like a computer-controlled microwave oven, so we thought it's possible some information might have been hidden in the oven. We also seized Fido.
So Fido, is this some sort of computer technology?
That's his dog. His dog had a tracking chip under the skin, and we felt it was very possible that information could have been hidden in that tracking chip. And as you understand from our Overreact training, any potential piece of evidence, no matter how incredibly stupid it sounds, must be seized.
All right. I think the jury's heard enough. Let's stop reading the list. So can you tell the jury what you found when you brought all of this back to your lab to analyze it?
We found the email the journalist's source had sent to the journalist.
Okay, so please turn your binder to Exhibit 3. Is this the email that you were referring to?
I'm not sure I have the right one. Yes, I do.
Okay, Your Honor, once again, admitting this in
Any
evidence.
objection to admission? It's admitted.
Okay, so this is published once again to the jury, but it's awfully small. Could you please read the entire email to the jury?
Sure. From truthseeker@freemail.com, sent Wednesday, February 24th, 2010, 11:27 a.m., to Simon Ross, subject my twit face. Simon, I know you write for the Technology Beat and have been writing some quality work on privacy issues. You're going to love this. Attached are screenshots from Biz Zuckerson's laptop, direct from the source. Screenshots showing an instant messaging conversation exposing Mr. Twitface's plan for the future. And what a scary plan it is. Read the IM first. Then you have to watch the attached video. The video came from Biz's webcam and shows the party mentioned in the IM. You'll recognize a few faces. And finally, the slide deck, which lays out the plan. The world has to know the truth. An anonymous source.
So, thank you. In the binder, there's exhibits 4, 5, and 6. 5 somehow is a animated video that sits inside a binder. So, Your Honor, I'd ask your permission to show exhibits 4, 5, and 6 to the jury and move them into evidence.
Any objection to publication and edition?
So, Mr. Stroker, if you would, maybe take control of the bailiff's computer. I don't think he's going to mind.
No.
So this is Exhibit 4. Could you please explain to the jury what Exhibit 4 is?
This was the IM chat attached to the email. It's a chat between Biz Zuckerson and somebody named Sheeta NMRC.
And again, this was found on the journalist's computer.
This was on the
attached to
journalist's
email.
computer.
Okay, and if you could read that IM chat.
So Biz Zuckerson says to Sheeta NMRC, yeah, so if you ever need info about anyone, just ask. I have over 500 million emails, pictures, addresses. Sheeta NMRC. What? How'd you manage that one? Biz Zuckerson. I don't know why. They trust me, dumb fucks. Anyway, I'm sorry you're going to miss my evil plot party, Winky. Sheeta NMRC. Evil plot party? What's that? Biz Zuckerson. Oh, you know, get all of my rich and powerful peeps together, coordinate our plot for world domination. Oprah's got some crazy-ass ideas, I got to say. And Bill Clinton, well, you know him, Winky. But I think my plan is pretty tight.
Okay. Thank you. Now, if we will turn to Exhibit 5, which the judges said we can show the jury. So what is Exhibit 5?
So, I'm sorry, Exhibit 5 was an excerpt from the video that was also seized from the journalist's laptop.
And can you play the video? Were you able to get this?
I was, after much playing around and actually getting the right application loaded, I am able to play this video.
All right.
Smoke and mirrors, if I can actually get it to want to come up. Sorry, having some technical difficulties. Well, I'd like to show the video, but it seems my laptop locked up.
I'm going to minimize.
Does anybody here know anything about computers?
Hate when that happens. Give me 1 second. There we go. Why don't we come back to the video?
Okay, that's fine. It probably wasn't worth all the buildup anyway. Could you describe for the jury what we might have seen? This is like that Brady Bunch episode where Sidney didn't show up for the magic trick. Could you tell them what you might have seen?
And we will be able to show it, but what you might have seen was a bunch of people in Biz Zuckerson's house looking at a laptop through the laptop's webcam.
Okay. And then turn to Exhibit 6, please. Is your computer up for that, or is it just not coming up?
No, which one was Exhibit 6?
The slides.
The slides are on.
No, that's fine. Just read the slides. Oh, you don't even have a copy of them. All right. Could you describe the travails of live TV, right? Could you describe what Slide 6 basically?
Well, Slide 6, which were actually 3 slides, were 3 PowerPoint slides showing something called an evil plan for world domination.
Okay. Your Honor, in light of technical difficulties, we ask leave to display these at some later point.
We will suspend the rules of evidence at
That's
your
wonderful.
wish.
Okay, so let's turn back to the sequence of your investigation, Agent Stroker. So you have this email with the attachments. What did you do next?
Well, I analyzed the email headers. They included the IP address of the computer used to send the email.
And where did that IP address lead you?
It led me to Leet Coffee and Tea in Burbank, California.
Okay, so turning your binder to Exhibit 7.
Which I'm working on. Let's try this again.
That was the song and dance part of the show.
Seriously.
Oh, there we go. Okay.
I can now show.
Just let's skip the video. Skip the video, but here are the
Okay,
slides.
but I can show the evil slides taking over the world. I
Okay.
believe that's Pinky and the Brain. something for requirements for world domination, money, power, and stealth, and something with a guy named Dr. Evil.
Got it. Okay. And then we were on Exhibit 7, if you could please.
Right. So that was, this is the stipulation. I believe you had worked out with the defense attorney showing we had executed a search warrant on Mr. Gob Bluth of Bluth Industries Internet Access, and he was able to provide us the IP information that led us to the Elite Coffee and Tea in Burbank.
Okay. And so this document is what helped you figure out where that IP address originated?
That is correct.
Okay. And so what did you do next?
Well, on February 27th, I visited the cafe.
And what happened during your visit?
Well, other than getting a very nice cappuccino, it looked like a dead end to me. The cafe didn't keep any logs of the people who used their computer. They also didn't accept credit cards. Guests paid with cash only.
And what did you do?
Well, I was about to leave when I suddenly noticed surveillance cameras on the wall.
So a cafe needed a video surveillance system?
I guess they must have read Miss Battalia's handbook.
Gotcha, right. And so what did you do?
Well, I was surprised by that, and I explained that, I was surprised by that too. They explained that they had been having some laptop thefts recently, and so that's why they put the video surveillance system in.
So did you ask about the video surveillance system?
Well, I asked for a copy of the video recorded at the time the email message was sent. The owner was just so happy to help, provided me a burned DVD with the tape of the entire day.
Your Honor, we're happy that we didn't have time to take this video because it probably wouldn't work anyway, but I'd like you to look at Exhibit 8 and explain what you're looking at.
Well, and I'll show the jury in a second, but this is a still from the video taken that day, the minute after the email was sent. This is exactly how it appeared when I visited.
Okay, and what else interested you about the video that we will show the jury?
Well, only 2 customers were in the cafe at the time the message was sent. In fact, it was a slow day, and these were the only 2 customers in the cafe the entire day.
So, Your Honor, I'd ask leave to publish the photo to the jury.
Any objection? Nope. Yes, you may.
Okay. And so what did you do with this still?
Well, obviously, I showed the video to Mr. Zuckerson and Miss Battaglia and hoped they would recognize one of the 2 people on here.
And did they recognize?
Yes, they immediately recognized Weasel. Obviously, from this picture, you can tell this is exactly the defendant at the end of the table here.
Your Honor, if the record would reflect that the witness has identified the defendant as the person appearing in the...
The record shall reflect.
Okay. And so what did you do next?
Well, with this information, we got a search warrant to search Weasel's house.
When did that search occur?
February 28th.
So you were moving pretty quickly at this point.
Well, you know how we are at overreact. Never react, always overreact.
What happened next?
Well, we searched his house and we seized 5 computers. Well, at least we seized the 5 that were actually working. I think he said something about having 42.
Okay. And did you find anything on these computers?
Many things. First, we found copies of the code used in the exploit.
And so did you analyze the exploit?
Yes, and in my expert opinion, these are exact copies of the code Battaglia found on my TwitFace's systems.
And what else did you find?
The computer had a Tor client installed.
So was there anything else?
Well, copies of the video and screenshots sent to the journalist. Again, a forensic comparison confirmed these are identical copies to those sent to the journalist.
Anything else?
Well, I analyzed the email messages stored on Weasel's computer. I found in Weasel's sent folder a copy of the message sent to the journalist with the attachments.
Seems like an implausibly good case you were building.
I'll tell you, we had overreact.
Okay. And what else did you find in the email account?
2 other pieces of email that seemed relevant to the case.
So, Your Honor, we'd like to turn to Exhibit 9 and 10. Perhaps to give Agent Stroker a break, we could have the defendant read from Exhibits 9 and 10.
Is there any possible objection of having your client actually read a piece of evidence to the jury?
Your Honor, I invoke Rule 23, which is the dramatic license rule.
Oh.
So this would actually help us.
You get me every time with that.
Okay, so you guys hear me? Okay.
Yeah,
What exactly am I supposed to be reading from
the
this?
entire
The
thing.
whole thing.
The whole thing. All right, my apologies. Even the headers, or
Why don't you skip to the body?
Skip to the good stuff.
skip to the bottom? Awesome, count me in. No, okay. Saw the news about Biz Zuckerson. Ouch. I always suspected bad things about his motives, but didn't expect things to be that bad. If you ask me, this will do great things for your membership roles. Enjoy the limelight. Social network privacy is sure to be a big topic of debate now. We'd love to have you. We'd love to have you give us a view of things, especially in light of the My Twit Face fiasco. Can you come talk to Fred 2010? We'll cover all expenses and we'll pay you our usual $5,000 honorarium. John Jones, founder, Fred.
And then there's a response email.
Okay. John, awesome. Count me in.
Okay.
Weasel.
You seemed pained by that. Perhaps I should have the agent read the next email. Would you like that? Or do you want to read the next one? There's another one. Now, Agent Stroker, why don't you read the next one?
I'll read it.
Okay.
From Weasel. Friends, users are up 75%. I continue to be amazed how many people are waking up and realizing the truth. We don't know exactly how many are female MTF users or how they came in from the press coverage, but one thing is for sure, everyone who works on this project owes a debt of gratitude to whoever leaked the horrible truth behind My Twit Face. W. Would you like me to continue reading the rest of those, Mr. Rome?
Let me see what else is on here. No, I think that's okay. I think that's enough to get a flavor for that. Again, this will be published back for the jury. Okay, so you find all of this information on the defendant's computer. What do you do next?
Well, next thing we did was we obtained a warrant and arrested Weasel, and we read him his rights.
And did he say anything after you read him his rights?
Yes, he did. If I could turn to my report.
Okay.
He said, and I quote, "I did it. I spied on the CEO, but just to expose him for the privacy-hating nut job he is. I'm glad I did it. Now the world knows what he's really all about."
That seems like a great place to stop. It's your witness.
Stroker.
Agent Stroker, sir.
Agent Stroker, pardon me. I just have a few questions, just to make crystal clear. The video
Yes.
that we were unable to show to the jury of the party at Mr. Zuckerson's home, that video did not include any accompanying audio, did it?
No, it did not. It was silent, but you could definitely see people speaking, their mouths were moving.
But the video itself was silent.
The video was silent.
You did not discover any other audio recordings
No audio tracks
in
at
your
all.
search. Okay. My other question, Agent Stroker, what evidence did you uncover of the purported financial motive of my client?
Well, obviously those two emails showing the $5,000 honorarium he was getting and all the new users he was getting subscribed to his service.
But all of that happened after the exploit. What evidence do you have of my client's motivation prior to or during the exploit?
Well, understand, we at Overreact clearly look at pre and post motivation, and obviously those emails show motive.
Are you suggesting that my client formulated a motivation after the exploit, then went back in time, and thereby was motivated by things that happened after the act?
I would assume so. You're the attorney.
I just want to make very clear that, no, actually, I'll just leave it there. I think I've done enough. Thank you.
Mr. Rome, do you have any redirect?
One question. You're not actually saying that time travel was involved in this case, are you?
No, I'm not.
No further questions.
Anything more, Mr. Bankston, on time travel? Nothing further? Okay. You're excused. Thank you.
Thank you.
Mr. Rome, do you have further witnesses?
No further witnesses, Your Honor.
Mr. Opsahl or Mr. Bankston, do you have anything you would like to present to the court at this time?
Yes, Your Honor. We would like to move to dismiss all claims pursuant to Federal Rule of Criminal Procedure 29 because the prosecution has failed to provide sufficient evidence to sustain a conviction. In particular, as to the wiretapping charge concerning the video of Mr. Zuckerson's party. As the prosecution's own witnesses made clear, the video was silent, without any audio recording accompanying it. And all of the federal circuit courts to consider the question have held that such silent video recording does not violate the wiretapping statute. Your Honor, Title III is amended by ECPA, the Electronic Communications Privacy Act, otherwise known as the Wiretap Act. Creates criminal and civil liability for the interception, in other words, the acquisition by a device, of any oral, with an O, wire or electronic communication without the consent of a party to that communication. Oral communications are essentially spoken words that are uttered by someone with a reasonable expectation that they won't be recorded. A wire communication is also a spoken or otherwise oral, with an AU, communication, but only those that are transmitted over the internet, the telephone network, or the like. Third and finally, electronic communications are any transmitted communications that are not wire communications, whether they contain text or images or video or sound or any other sign or signal. Unless you are a party to a communication or have the consent of a party, intercepting any oral, wire, or electronic communication is a violation of the statute. So, for example, secret monitoring of your emails while they're being transmitted, wiretapping of your telephone calls, or secret eavesdropping using a microphone planted in your house would all violate Title III. However, the secret use of a webcam or a radio-controlled camera to photograph you inside your home or office or other private space is not currently prohibited by Title III, because in such case there would be no oral, wire, or electronic communication to be intercepted. At most, the only communication would be the electronic communications between the camera and the person who's remotely operating it. And that person is a party to those communications, as opposed to a third party intercepting those communications. So Title III simply doesn't apply. This has been held first in 1984 by the Seventh Circuit in United States v. Torres, in an opinion authored by the esteemed Judge Posner. Multiple circuit courts have since agreed with that court. The Second Circuit in U.S. v. Biasucci, the Fifth Circuit in U.S. v. Cuevas Sanchez, the Tenth Circuit in U.S. v. Mesa Rincon, the Ninth Circuit in U.S. v. Coyo Mejian, the Eighth Circuit in U.S. v. Falls, and the Third Circuit in U.S. v. Williams. These decisions, most of which were denied review and therefore implicitly affirmed by the Supreme Court, were typically in the context of an appeal of the denial of a motion to suppress video evidence in a criminal case. But this logic has been followed uniformly in other civil cases as well. In the year 2000, for example, the Court for the Eastern District of Pennsylvania held in Out and Ride v. Circuit City Stores Incorporated that an employer's use of a silent video surveillance system in an employee's office did not violate the Wiretap Act because it did not record sound. Nor did my client ever record any sound to accompany the video taken by Mr. Zuckerson's webcam. Therefore, following a stack of precedent that the prosecution cannot counter with any case law, that charge must be dismissed. I would also like to note, Your Honor, that the prosecution has notably failed to provide sufficient evidence for the felony enhancement for the 1030A2C computer fraud and abuse charge. There is simply no evidence that my client had a commercial motive or was seeking a personal financial gain from his conduct.
All right, thank you, Mr. Bankston. Is there anything more to your argument on the Rule 29 motion?
No, Your Honor.
All right. Let me ask you a couple questions here, particularly on your first argument about the request to dismiss the wiretapping charge of oral communication. Does your argument depend on the defendant, assuming the defendant was engaged in this activity, being a party to the communication by having enabled the webcam?
No, Your Honor. It primarily turns on the definition of an oral communication, which I don't have this statute in front of me, but is essentially a communication by the human voice that is intercepted in circumstances where the person has a reasonable expectation of privacy. So for lack of that recording, there is no oral communication. And I'd further argue, to the extent there were, one could argue that there was no expectation of privacy in this party. But most importantly, oral communications are communications of the human voice, period. And this video recording did not capture any communication via the human voice.
All right. Thank you, Mr. Bankston.
Thank
Mr. Ohm, do you have any argument in rebuttal?
I do, Your Honor. Wonderful arguments, I might add. So just to make sure I understand the scope and scale of the defendant's motion, this is targeting count 1 and count 3, if I followed you correctly?
I think he made a general Rule 29 motion, but in particular he was challenged.
So let me take count 3 first. And as I understand the hastily stated and ill-supported argument, it was that the government failed to present any evidence that would prove the financial motive for the third count, the hacking count, which is necessary for the felony conviction. The government agrees that we have to show commercial advantage or private financial motive, and the government argues that that burden was met, at least for the Rule 29 phase, by the testimony of Agent Stroker, who brought in the two pieces of email that talked about, number one, the $5,000 honorarium that came to the defendant a mere few days after the revelation of this material, and almost more importantly, number two, the uptick in users to his own service, the 75% increase in users, which I think is sufficient for the government's burden at this stage to show the motive that's necessary to sustain the felony. So that's on that one. On count one, and just to make sure we're all on the same page, this is about the interception of the silent video. The government concedes that the defendant has an impressively long list of precedent to suggest that silent video, for some reason, does not amount to a wiretap violation, and if by mere happenstance the microphone had been enabled as well, this would amount to a federal crime. And so the government has several responses to this. First, as a textual matter, and I do have the definition right here, and I love this because it shows that Congress understands the concept of head recursion. Oral communication means any oral communication, and then it goes on to say, uttered by a person, and then there's more. And so the first thing the government would argue is, essentially Congress has left this undefined. The only thing that we're provided is that the crime is for the interception of an oral communication. And the government argues that that's exactly what was intercepted in this case. The people, and I understand the jury hasn't seen this, but you have, Your Honor, the people are very visibly and very clearly moving their lips throughout the video. And because oral communication remains undefined in the statute, or mostly undefined, we just fall back on the normal, ordinary English meaning of these terms. And I think if we pull out the ordinary English definitions, they're capacious enough to include situations like this where we can't even hear. But more importantly, the government would argue that as a matter of policy, what the defendant is arguing is very, very troubling. So the defendant is arguing that this statute, which is the primary principal comprehensive privacy statute for the protection of things like oral communications, wire communications, electronic communications, basically has a loophole that's big enough for a Mack truck to drive through. That basically, for whatever reason, Congress in its inestimable wisdom thought that they were going to regulate in a very fine-tuned way what we say, what we send on the wires, what we send electronically, in all sorts of things, and yet for some reason leave completely unprotected, for example, a video camera placed inside a locker room, or a video camera placed inside a shower or a bathroom. That just cannot be the case that Congress would have such an odd omission. The last policy argument that the government would rely on is to remind the court, as you know well, that this statute is not just a criminal statute. That this statute also governs the behavior of the police and of law enforcement. And that a ruling that Congress meant to exclude silent video in criminal cases would also mean that Congress meant to exclude silent video in law enforcement cases. This would basically be a license, a blank check, to all government law enforcement to install silent video cameras wherever they want, for any reason, without the statute, which again is the primary arbiter of privacy when it comes to things like interception. This would say that the statute has nothing to say whatsoever about this wholly invasive law enforcement technique. And so for all of these reasons, we urge the court to deny both motions. Thank you.
Thank you, Mr. Rahm. Mr. Bankston, do you have any other rebuttal to that?
The law doesn't have anything to say about this especially invasive surveillance technique that could be used by the government. And if this were a policy debate, I would agree with my esteemed colleague on the other side of the courtroom. In fact, I have testified to Congress saying that a good policy was, in my role as an EFF privacy advocate, that it would be a good thing for Congress to update the law in this manner. Judge Posner, over 25 years ago, suggested that Congress might want to look into this and update the wiretap law to cover silent video surveillance. But it has not done so. And we are not here for a policy debate. We are here to determine the fate of this man. And whether I or Mr. Ohm or anyone else disagrees with the policy decision that Congress made when it wrote this law. It did make that decision, and that is the law that we are considering today. As for the outrageous suggestion that silent video where you can see people talking is the capture of the content of an utterance of the human voice, I'll simply say that 7 circuit courts of appeal have decided as a flat rule that silent video recording, including of people who may be talking, is not covered by this statute. And so I think that's all I have to say.
All right, thank you, Mr. Bankston. And I should say I'm very glad we asked the jury to leave, because this, of course, is the kind of thing we wouldn't have the jurors listen to. But I've heard the argument and given it consideration and have seen the briefs as well. And based on what I've heard today, I'm ready to issue my ruling. And on count 1, I hereby...
And we will now take a mandatory 15-minute break and return with Judge Salgado's decision after everybody's had coffee.